Now back to the show. This is AM 650's The Law Show.
Welcome back. David Hobbs and Ian Giroday from Hobbs Giroday here in Vancouver are our guests on this episode of The Law Show, this holiday episode of The Law Show, perilously close to New Year's Eve as we all are. We still have our wits about us, and it's a wonderful occasion to sit here and talk about wills and estates. We talked about estate planning last time around. On this show, we're talking about the process of applying for a change or a variation to a will. And Ian, talk to us a little bit about it. We've identified to some extent the type of person who would typically come to Hobbs Giroday, asking you to have a look at their circumstances and perhaps act on their behalf and cause a will to be varied or changed. When you see that person, what sort of exchange typically would happen?
Okay, well, Sterling, the first thing is a very finite number of people or relationships to the deceased can actually bring a will's variation claim.
Okay, this is important, friends. If you're involved in a will and you're feeling a little shortchanged and you're not on this short list, you're out of luck. Who's on the short list that can ask in British Columbia for a change or a variation to a will, Ian?
Spouses, and that includes common law spouses, or someone in a marriage-like relationship, which I'm not sure is really all that different than a common law spouse.
Exactly, right.
And children, and the children can be either natural children or adopted children. Stepchildren don't qualify.
Interesting.
And so those are the people. So the first thing we need to ascertain is the person coming to see us.
Do they fit one of those categories?
Are they eligible?
Right. Now, David, you've mentioned this previously in the program today. You talked about infant children, but in the law, an infant child is anyone under what, 18 or 19?
Under 19.
Under 19. So if you're 16 and 17, the law refers to you as an infant, which doesn't make you very happy, but you can still apply. But if you're under 18, under 19, can you apply as an individual for a will's variation, or do you have to have literally an accompanying adult make the application on your behalf?
Well, the rules of court provide that if you're an infant, then you're disabled from commencing an action.
Oh.
So you need a litigation guardian, i.e. an adult person.
Right.
And there's a process with lawyers where the lawyer certifies the fitness of the litigation guardian, which is a process intended to protect the infant from not having an inappropriate litigation guardian. Typically it's a parent. You go through all that process, and the litigation guardian acts as the legal representative. They're really, in effect, the legal plaintiff for the infant.
Right.
Okay. Or defendant, as the case may be. So there's some rules and process surrounding infants. Same for disabled people that are mentally disabled, but who have to commence an action. They need a litigation guardian.
Okay.
But this discussion we're having right at the moment, I mean, maybe it's helpful to the listeners to take an example. And what comes to mind to me is that what we see are one spouse passes away, the other spouse is healthy, and so they enter a new relationship, which may become a common law spouse. So I'm 50 or 60 years old, my husband or my wife passes away. Mm-hmm. I now take up with another person who moves in with me, or I move in with them.
Right.
We mix our assets and our interests and so on. And typically, my children of my first marriage, they're not the children of my new spouse, or common law spouse, or partner. And quite often, there's not happiness in this relationship. We unfortunately refer to dysfunctional families and these sorts of things. It's a mixture of people. They come from different biological pools.
Right.
They don't get along together. They're suspicious of each other. They may be to the point that they're distrustful of each other, i.e. that this person has come into my father or mother's life just to get their money.
Sure.
And to make sure that I don't get it.
Right.
And so this becomes the chemistry of a very common pattern of estate litigation. And quite often you'll read the will of the surviving partner, the person who passes away, and that will may give nothing to this second spouse,
Right.
who I lived with for 10 or 15 years. and that person will have very powerful legal and moral rights under the Wills Variation Act to claw back from the children of the first marriage. Or we see it the other way sometimes, where the new spouse got everything and the adult children got nothing.
Right.
So these are very common battlegrounds
Well,
for wills variation.
this is the stuff of legend and Hollywood movies. I mean, you start flipping through the tabs at the supermarket, and there's stuff on this estate battles in every episode or every edition of the National Enquirer and all of those entertainment magazines. It really is quite legendary Family Feud material, isn't it, Ian?
It certainly is. And, just to add one layer to David's description, quite often spouses have mirror wills or close to mirror wills where the survivor will inherit the entire estate of the other.
Okay.
So, the survivor may be entering into this new relationship with a new spouse or partner, and the adult children haven't received anything from their parent who first deceased, and now there's a new person in the surviving parent's life who may take the entire estate. And so there's a sense that somehow the estate that was built as this family unit is now going to a stranger.
Right. And a lot of disorientation and a feeling that literally the rug's been pulled out right from underneath you, David.
Well, and the level of dislike can be many generations. So I may not like my mother or father's new spouse that I've met in the last 5 or 10 years of their life, but I even dislike more of their children. And what really galls me is they're going to end up with everything. Right. The assets are going to move from one side of the family to the other side of the family.
So when someone comes to Hobbs Giroday with this kind of scenario, suppose they are an adult child of the first marriage. Mom died years ago, dad remarried, younger woman, new family, we don't particularly get along, but live and let live. Now dad's gone, and it turns out he left everything to her. And wait a second, that's just wrong, and I want some satisfaction here. You hear this story a fair bit?
Frequently, and I was going to mention to you Coley Hall. You being a sports aficionado would know the name Coley Hall.
Absolutely.
And sort of the Hall estate is a good read for looking at adult children, first marriage, new relationship, and the contest. Certainly one of the principles that seems to come out of that case and related cases is that the 10, 15-year relationship of the second spouse, because the act recognizes legal and moral obligation to that spouse, they tend to trump the adult children of the first marriage to a degree. There's an advantage really to this this second spouse when in the contest with the children of the first marriage.
Interesting, but
they only have a moral obligation owed to them as adult children. They don't have the legal obligation.
And if there isn't a great deal of estate to be distributed in the first place, chances are those adult kids are just out of luck.
Well, you raise a point we haven't talked about, and that is there's a big difference between analyzing wills variation for small estates where there's not enough to go around,
right,
versus big estates where there's lots to go around.
Right, and those are the stuff we read about in the supermarkets.
Yeah, and
millions at play here.
Because if there's millions at play, I can satisfy my moral obligation easily to all my children and the spouse and so on.
Just because there's enough money to go around.
Right. And where it's a very small estate, say it's only a few $100,000, say my surviving spouse is 60 or 70 years old and badly needs money and has no money, she may end up with that whole estate, and the adult children may not be able to encroach on that at all because of the size of the estate.
Okay, so when you are interviewing prospective clients, they're interviewing you. They're sitting there going, are these the sort of fellows I want to have as my team in court when I take on the clan for my piece of the pie? And at the same time, you're looking at this person going, well, let's hear about the circumstances of your case, because you're trying to determine whether you want to act on behalf of this person, right?
Well, you're getting into a topic, I think, which is the fee arrangement with the client, even though you may not have been thinking about that. But typically, wills variation is done on a contingency fee basis.
Oh, okay.
So you're at risk with the client in the sense that the lawyer won't get a fee unless something's recovered. So you tend to analyze the case as to risk and likely outcome because your fee is dependent on it as a percentage of the recovery. That's a contingency fee.
Okay.
And so and I think all lawyers, you're doing some due diligence to decide whether or not you wish to take the risk with the client of trying to recover something, which you have a vested interest in. And it's a good thing and a bad thing. It allows people to pursue litigation who can't afford to pay lawyers by the hour, because it's a risk exercise.
Right.
And I think there's some symmetry between the client and the lawyer because you're both trying to decide, is this worthwhile doing? I have a financial interest in it and you have a financial interest in it. And that's the essence of contingency fee.
Yeah, certainly determining whether you want to take the case on or not and on what fee basis is part of the process of a first or second meeting.
Right.
But fundamentally, we're getting their story, understanding what the evidence might be so that we can advise them whether they have a case that's worth pursuing or not.
Right.
And certainly we can talk about things like what's in the estate. Does the estate have sufficient assets in it to warrant seeking a variation? How much will it cost to litigate that? Is the cost worth the potential benefit? Are there transactions that were done by the will maker that might be attacked to bring more assets into the estate? All sorts of issues on the merits and on advice and on deciding whether there's a case to pursue and on what fee basis.
And is that initial encounter with a prospective client, gentlemen, still a free occasion for the interested party, the person who comes to Hobbs Giroday and goes, do I have a case here? And if I do, will you be my lawyers? As that meeting's still a complimentary exercise.
It is. I mean, normally we speak to people and just decide whether it's worthwhile to have a meeting or not.
Right.
But once we reach that point, then we're going to have a meeting. There's usually no obligation at that meeting
Okay.
whatsoever.
HobbsGiroday.com is the website for David and Ian's firm in Vancouver. HobbsGiroday.com. All of the contact information, should you be contemplating a meeting, is on the website. Email addresses, telephone numbers, the whole bit. This is The Law Show here on AM 650 with more still ahead. Stay with us.
There's more of the show still ahead. This is AM 650's The Law Show.